This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about post-procurement fraud as it applies to rescission in the state of Michigan, because Michigan is just a little different when dealing with rescission than other states. Rescission in Michigan requires pre-procurement fraud and does not allow rescission for post-procurement fraud. So that a lie about where a vehicle was garaged after the policy inception date cannot be a basis for rescission in Michigan. This appeal turned on whether fraud occurred in relation to an April 26, 2018 renewal contract for a policy of insurance under the No Fault Act issued by plaintiff Encompass Indemnity Company. In a case entitled Samuel Tourkow versus Michael Thomas Fox et al., including Encompass Indemnity Company, the Court of Appeals of Michigan on February 12, 2025, resolved the dispute. The plaintiff, Encompass Indemnity Company, issued a no-fault insurance policy to Jon and Joyce Fox, with Michael Fox added as an additional insured. The dispute centered on whether fraud occurred in relation to the renewal of the policy on April 26, 2018. Michael Fox was involved in an accident on December 26, 2018, which led to a lawsuit filed by David Tourkow on behalf of Samuel Tourkow. Encompass rescinded the policy, alleging material misrepresentations about the garaging location of Michael's vehicle, a Ford F-150. Michael then filed a third-party claim against Sweet Insurance Agency alleging negligence. The trial court initially granted summary disposition in favor of Encompass and Sweet, but this decision was appealed. The appellate court found that the trial court erred in its conclusions regarding pre-procurement and post-procurement fraud, and that Michael's due process rights were violated. The Court of Appeals found that the trial court's grant of summary disposition in favor of Encompass was simply erroneous. The Foxes argued the trial court erred by granting summary disposition in favor of Encompass and abused its discretion by declaring the April 26, 2018 renewal policy void ab initio, or from its inception. The circumstances under which an insurer may invalidate an insurance contract based on fraud in Michigan now requires a court to separate fraud into two broad categories based on when it occurred. 1. Fraud that occurred before the parties entered into an insurance contract, referred to as pre-procurement fraud, and 2. Fraud that occurred after the parties entered into an insurance contract, post-procurement fraud. If fraud occurred before the policies entered into the insurance contract, then rescission is available as a remedy. If fraud occurred after the contract was signed but before litigation began, then rescission is available as a remedy only if the fraud substantially breached the contract. And finally, if fraud occurred after litigation began, which necessarily also means that it occurred after the contract was signed, then rescission is not available as a remedy in Michigan. In sum, the trial court erred by granting summary disposition in favor of Encompass based on the trial court's erroneous conclusion that pre-procurement fraud occurred in relation to the vehicle involved in the accident, a Ford F-150, because the policy was in force when the renewal occurred. The Court of Appeals concluded that it follows, therefore, that the trial court abused its discretion by holding the renewal policy was void ab initio, that is, from its inception, on the basis of the alleged fraud. The decision in favor of Encompass was, therefore, reversed because the trial court erred by granting summary judgment in favor of Encompass. Rescission, in my opinion, is an equitable remedy based upon the concept of fairness. In most states, a misrepresentation of a material fact, like where a vehicle is garaged, is grounds for rescission even if the misrepresentation was innocent or material. In Michigan, however, the Court of Appeals explained that rescission requires evidence of fraud, much more than just a misrepresentation, in the inception of the policy before the policy was issued. In this case, the fraud about the garaging of the vehicle happened after the policy was issued, so there was no right to rescind in Michigan. On the same facts, rescission would be allowed in many states, if not all. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 times a week, and you'll gain access to the more than 4,950 blog postings. You can also subscribe to the videos. They are also free. And please tell your friends and colleagues about the blog and the videos and let them also subscribe. If you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.